Hi, everyone. Welcome to our third and final PowerPoint presentation on the topics of the contracts checklist. When we last left off, we were talking about the concepts of capacity and consent, and the idea that a party cannot freely give their consent if they've been lied to. And that's the concept of fraud. So to answer the question that I left off with at the end of the last PowerPoint, if a person feels that they have been defrauded in a contract, then he can prove and set aside the contract by proving that, number one, the other party made what's called a material misrepresentation about a fact, and that the other party relied on that material misrepresentation to their detriment. So what does that mean? Material misrepresentation. Here, the word material means significant or important. So we're talking about a misrepresentation, or in other words, a lie, about a concept that was important to the other party. So if the state of the transmission was important, or knowing if the car was in an accident before the sale was important, those are material to the contract, and therefore lies about them are material misrepresentations. And if somebody relies on that material misrepresentation as an incentive to enter into the contract, then that can be the basis for fraud. So what this basically means is don't lie in your contracting, because if you lie to the other party, that could be the basis of a fraud claim. It's also a crime, not just a contracts case. I wanted you to also look at the example in your textbook of Hess versus Chase Manhattan Bank, a really good example of how fraud works. The last thing I just want to say about fraud is that it has to, similar to what we learned about with the law of defamation, it's a material misrepresentation of fact only. Giving an opinion cannot be the basis of fraud. So if someone asks me, how is your car running? And I say, my car runs fine. That's opinion, right? I mean, what I envision running fine and what you envision or you picture as running fine could be two very different things. And so opinion about what the item is for sale or opinion about its condition, that cannot be the basis of fraud. But certainly stating a fact that a car was either in an accident or not in an accident, that is a factual basis. Okay, the last one to talk about consent has to do with mistake. This is a really fascinating topic in contracting. What happens when somebody makes a mistake? So as your book describes, there's two types of mistakes. There's unilateral mistakes, meaning only one of the contracting parties made the mistake. And then there's bilateral mistakes, meaning both parties made a mistake. And it actually has an effect on who can void or set aside the contract based on the mistake. By the way, take a look at that Jaguar case in your book. It's a really good example of a unilateral mistake. So a unilateral mistake goes like this. One party makes an error. Let's say you print the price of an item wrong. And then you go to, and someone goes to purchase and says, oh, you were selling your Jaguar for $10, not $100,000. I'll buy it for $10. So unilateral mistake happens when only one party has made the mistake, not both. The second type of mistake is called mutual mistake. And although I didn't list it here, I really want you to look at the case in your book called Sherwood versus Walker. It's a really fun ancient case about the sale of a cow, and it's really well studied for the concept of mutual mistake. What happens when both parties make a contract on a mistaken belief? In this case, it was the mistaken belief that the cow could have babies and therefore the mistake was actually that the cow couldn't have babies and therefore the cow wasn't worth as much money. But then it turned out that the cow could have babies. What do you do then when both parties make a decision based on what they both mistakenly believe? So take a look at those case examples and see under what conditions there can be a mistake that requires or allows one or both of the parties to set aside the contract. Okay, I want to leave the bulk of this time for this last video to talk about the last and final checklist item, which is called the Statute of Frauds. This is a really important concept in the law, and it's the concept that tells us when do contracts have to be in writing. Remember, this entire unit, we're really focused on the idea of when a contract is going to be enforceable. Sorry, got interrupted there. What I was talking about was the concept, this whole concept in this chapter, in this unit, is to talk about what makes an agreement enforceable. What allows one party to go to court and say, I have a contract the other party didn't follow? And one of the important questions that we all ask ourselves is, when a party takes a case to court to say the other has breached or not followed their contract, does that contract need to be in writing? So what we're asking ourselves is, do we have to put a contract in writing for it to be enforceable? Or can we have verbal contracts? And the short answer to the question is, it depends. There is a rule that the United States adopted from England, which is called the Statute of Frauds. Again, not the statute, like the Statute of Liberty, but the Statute of Frauds. And the Statute of Frauds gives us the rules about which contracts must be in writing to be enforceable. Any contract that does not fall on this list, the court will enforce a verbal or oral contract. Now, you might be asking yourself, how do you prove that? If all you had is Sugarman's word versus Jones's word, how can you prove that the contract exists? Well, you prove it through sworn testimony. When we go to court, witnesses testify under oath about what happened, and we ask a jury to decide if that contract existed, and if so, what its terms were, based on the verbal testimony of the parties. Who do you believe? But that doesn't make the contract any less enforceable. The other way to look at this is, of course, to say that having a writing makes it easier to prove the contents of a contract or that a contract even existed, but that writing is not required. It just makes proving it easier. So which are the contracts that have to be in writing? This is the magic list. I'm going to go through these pretty quickly, and really only about half of them are pertinent to us in a discussion of business law. Number one, contracts for the sale of real estate, homes, land. Those must be in writing. You can't have a verbal contract for the sale of real estate. Contract to pay the debt of another person. This is what we call a guarantor. If someone has guaranteed a loan, meaning if you take out a loan and the bank has asked for a guarantee, that means somebody else has agreed to pay your debt if you can't. That contract between the guarantee and the bank, the guarantor, or the other way around, that has to be in writing. How about this one? Contracts that by their very nature last more than a year. That means the contract can't happen in less than 1 year. That's the magic. You might be saying, how does that work? When I go to work for my job, I just work until I quit. A contract where you can quit at any time, that's not a contract that lasts a year, because I can quit tomorrow. This is where I remind you guys that a lot of you have, and I have had in the past, an oral contract for employment. By you agreeing to go to work and getting paid, if you don't have it in writing or an employee handbook that you've signed, you have a verbal contract for employment, and that is completely legal. So what are we talking about with a contract that must last over a year? A really good example would go like this. Let's say it's September 1st of a given year, and I am planning a wedding to take place the following year in December. So like 14 months later, or not, that's more than that. I didn't do the math very well. Let's say I do a wedding 15 months or 16 months later, and I want to hire Jones's DJ company. So I hire Jones to be my DJ at my wedding that is 15 months away. I better get that contract in writing, because it is literally impossible for Jones to play as a DJ at my wedding in less than a year, because the event is 15 months away. Does that make sense? That contract has to be in writing. Okay, a couple that don't really have to do with business law is contracts made by an executive estate and contracts in consideration in marriage. So I'm just going to skip over those. But I do want to just quickly mention sales of goods over $500. In about 2 weeks, we're going to do a unit exactly just on the Uniform Commercial Code, and we're going to come back to this particular point in the Statute of Frauds. But that, because it's really a UCC rule, but that is also contracts that must be in writing. So what's the big takeaway here? Anything that's not on this list can be a verbal enforceable contract. So a contract to sell your bicycle for $200, your contract to go to work until one of you fires the other or you decide to quit, that can be a verbal contract. All services contracts that are less than a year can be verbal. Notice that it's sales of goods over $500, not services that are provided. This means that an awful lot of contracts are perfectly fine and enforceable just by our own testimony. So the last thing to talk about in this unit is when we say a contract must be in writing, what are we talking about for that writing? What does that writing have to look like? A lot of our contracts are on, the computer, 8.5 by 11 typed paper with signature lines and dates. But the truth is the rule is not nearly as strict as that. The writing can be on a napkin. And if you don't believe me, I want you to link to this case here where a napkin was found to be an enforceable, a written note on a napkin was found to be an enforceable binding contract in a case in Alaska. This is a pretty recent case. It's pretty neat that there was still a napkin case. But what are we really talking about? When we talk about a writing, we want to know what needs to be in the writing. Just enough reasonably certain terms that the parties know what we're talking about. If I say Sugarman, Carr, Bob Jones, is that sufficient to know what's for sale? Maybe not. But if I write Sugarman, 2010, Toyota Sienna, $1,000 for sale to Bob Jones, I think we actually have enough information to know that the terms are reasonably certain to enforce that contract. The other interesting thing is, for a writing, do the parties have to sign the writing? Of course, all of us think signatures make something official, and they do. But the trick here is that in order to find that a writing is sufficient to satisfy the statute of frauds, the court doesn't say that both parties' signatures have to be on it, just the party against whom enforcement is sought. That means the defendant. So if I write a little note, a little contract on like a sticky note like this, I got my little sticky pad here, and I give it to you that I'm going to sell you my car for, let's say, $600, and I put the name of the car, and we put a date on it, we put all the reasonably certain terms on that sticky note, and only you sign it, and I don't sign the sticky note, and then you want to sue me to enforce the sale of the car, if my signature is not on the document, the writing doesn't count. So the court is going to look for the defendant's signature on that writing, whatever the writing is. That's what we mean by the party against whom enforcement is sought. Well, thank you for bearing with me. I know these were 3 very long videos with a lot of dense information about what makes a contract enforceable. But the real big takeaway is just remember, contracts are agreements. That's all they are. But what makes them a contract is the idea that one party can go to court and enforce the terms against another party. But in order to do that, that agreement needs to meet all the items on this checklist. And you can see various pitfalls along the way where the court will say either that wasn't a contract or the contract is not enforceable due to fraud or mistake or something like that, or the lack of writing or lack of sufficient writing. So I look forward to talking to you about these issues on the discussion board. And in next unit, we're going to talk about what happens when there is an enforceable contract, but one party does not live up to its obligations and there's been a breach. So that's coming next week.